Nobody expected a livestock pond in Garfield County, Colorado, to cost the state's Water Resources Department $4.7 million. Nobody expected a third-generation wheat and cattle farmer with no legal training and a shop fax machine from 2003 to be the reason it did. Nobody expected any of it, which is part of why the settlement agreement, when it was finally signed in the fall of 2019, was handled quietly, without a press release, in the offices of a water law firm in Grand Junction that did not advertise the outcome to anyone. Wesley Pruitt was 67 years old by then. The pond was still on his property. It had been on his property since 1961, when his father Lawrence had dozed it into the draw below the home pasture with a rented Caterpillar D6, and before that the water it impounded had been running through that draw since before anyone in the Pruitt family had arrived in Garfield County to notice it. The state had told Wesley, in a letter dated June of 2016, that the pond was an unpermitted diversion of state water, and that he was required to drain it within 90 days and restore the draw to its natural channel, or face daily administrative fines that would begin at $200 and escalate from there. Wesley had read that letter 3 times. Then he had gone out to the machine shed and stood at the workbench for a while, looking at nothing in particular. He was not a man who made fast decisions. He was also not a man who drained ponds on the word of a letter. There's something about a person who doesn't have to prove anything. If you know what I mean, you'll know why this story is worth your time. Hit subscribe and stay with us. The draw that fed the pond ran off a limestone bench in the eastern portion of Wesley's ground, a reliable seep that produced water even in dry years when the wells in that part of Garfield County ran low. Wesley's grandfather, Harmon Pruitt, had found the seep in 1937, 2 years after he had homesteaded the acreage, and had recognized it for what it was, a consistent, modest, dependable source in a country where water was the first and last thing that determined whether a farming operation survived. He had diverted a small portion of the flow into a stock tank that first year and had begun thinking about something more permanent. Harmon Pruitt had come from western Kansas to Garfield County in 1935 during the worst of the drought years, following a rumor of ground that could still be had at a price a man with very little could reach. He was 31 years old when he filed his homestead claim and 29 when he had left Kansas. And in the 4 years between, he had worked construction and harvest labor across 3 states and had saved $411, which was what it had taken to get the land, a used team, and a winter's worth of supplies. He was not an educated man in any formal sense. He was a careful one. He had watched his neighbors in Kansas lose ground to arrangements that had looked solid until drought and low prices had tested them. And he had come away from that watching with a specific conviction that anything a man depended on for his operation needed to be documented, and that the documentation needed to be in a place that would outlast the man. In the spring of 1939, Harmon Pruitt drove to Glenwood Springs and filed a prior appropriation water rights claim with the Colorado State Engineer's Office for the seep on his eastern ground. The prior appropriation doctrine, the legal framework that governs water rights across most of the American West, operates on the principle that the first person to put water to beneficial use has a senior right to that water, which no subsequent user or government authority can diminish without compensation. A filing in 1939 would have a priority date of 1939, which in Colorado water law made it senior to virtually every agricultural or municipal water right filed in Garfield County in the subsequent 80 years. Harmon had not understood the full complexity of prior appropriation law. He had understood the core of it, that you filed first, that you documented your use, and that the paper you received from the state engineer's office meant that the water was yours in a way that something unwritten was not. He paid the filing fee, $3.50, and received his priority certificate and drove back to Garfield County and put the certificate in a metal deed box with his homestead papers and his land abstracts, and built his stock pond the following year and the larger impoundment, Wesley's Pond, in 1961, when his son Lawrence had the equipment and the time to do it properly. The deed box had passed from Harmon to Lawrence to Wesley in the way that important things pass in farming families. Not ceremonially, but practically, with a brief explanation of what was in it and where it was kept. Wesley had opened it a handful of times over the years. He knew the water rights certificate was in there. He had never had occasion to use it. He had occasion now. He found the certificate on the second evening after the state's letter arrived, after he had gone through the box once without finding it, and then gone back more carefully. It was in a paper sleeve with the homestead filing, which was why he had missed it the first time. The document was 80 years old, and the paper had browned at the edges, but the text was legible, and the state engineer's stamp and the filing date were clear. Priority date, April 22, 1939. Beneficial use, stock water and irrigation. Water source, unnamed Seep, Garfield County. Legal description matching Wesley's eastern parcel exactly. He took it to a water rights attorney in Rifle the following week. The attorney read it without speaking for several minutes. He looked up. He asked Wesley where he had found it. Wesley said the deed box. The attorney nodded the way a person nods when they are trying not to show what they are thinking too quickly. He said the certificate appeared to be valid. He said he would need to verify the filing against the state engineer's records before saying more. He said Wesley should not respond to the state's letter until they had spoken again. The verification took 9 days. The 1939 filing was in the state engineer's records in Denver, complete and correctly indexed under Pruitt, Harmon E., Garfield County, priority date April 22, 1939. The water rights attorney wrote a response to the State Water Resources Department on Wesley's behalf that ran to 14 pages. The response included a certified copy of the priority certificate, the verified state engineer's record, an 80-year documented history of beneficial use, and a legal analysis of the prior appropriation claim under Colorado water law that the attorney described to Wesley as, in his view, essentially airtight. The department did not respond for 6 weeks. When they did, the letter was from a different office, the legal division, not the compliance division that had sent the original notice. It requested additional documentation on the beneficial use history. Wesley's attorney provided it. There was another gap. Then a request for a meeting. The meeting was in Grand Junction in the spring of 2017. Wesley drove 2 hours each way and sat across a table from 3 department attorneys and a water rights administrator and said almost nothing because his attorney had told him not to say almost anything, and Wesley was good at that. His attorney did the talking. The department's attorneys asked questions. The water rights administrator made notes. The meeting produced a second meeting, and the second meeting produced a period of parallel legal research by both sides that lasted, with various interruptions, for approximately 2 years. What the department's attorneys had discovered, in the course of their research, was that the prior appropriation claim was not the only problem. The 1939 filing, once the department's records team had pulled the full index for that priority date and location, had surfaced an additional issue. The state's 2016 compliance letter had been based on a hydrological survey that had misidentified the source of Wesley's Pond's inflow as a tributary of a state-administered waterway, when the actual source, the seep on the eastern bench, was a groundwater emergence that was legally separate from the surface water system the state had jurisdiction over. The compliance action had been, in the department's own internal assessment, incorrectly predicated from the beginning. The 1939 filing had not just established a senior right, it had exposed the factual error underlying the entire enforcement action. The department faced a choice between protracted litigation against an 80-year prior appropriation claim and a groundwater emergence misclassification that their own hydrologists had now confirmed, or a settlement that acknowledged the right, withdrew the compliance action, and compensated Wesley Pruitt for the costs and damages of 3 years of administrative and legal proceedings. They chose the settlement. $4.7 million. Withdrawn compliance action. A letter from the department formally acknowledging the validity of the 1939 water rights filing and the Pruitt family's senior right to the seep and its downstream impoundment. Wesley's attorney called him with a settlement number On a Thursday afternoon in August of 2019, Wesley was in the shop when the call came, and he walked outside and stood in the driveway and listened to the number and did not say anything for a moment. Then he said, Harmon would have called that a fair return on $3.50. He said it without any particular emotion. It was just the true thing, so he said it. The pond is still there. The cattle still water at it. The draw still runs off the eastern bench in wet years and dry years the way it ran when Harmon Pruitt first found it in 1937, following a rumor of ground that could still be had. He had found the ground. He had found the water. He had driven to Glenwood Springs and paid $3.50 and put the certificate in a box with his other important papers. He could not have known. He could not have known what the state would decide 80 years later, or what a compliance letter would look like, or what a water rights attorney in Rifle would say when he read what Harmon had filed. He just knew what his Kansas neighbors had taught him, the hard way, about depending on arrangements that weren't written down. He wrote it down. He filed it. He put the paper in a box. The water kept running. The paper kept waiting. And when the day came that someone needed both of them, they were exactly where he had left them.